Hey guys, attorney Marc Victor here. I am the founder of the Attorneys for Freedom law firm, and we're based in Chandler, Arizona, as well as Honolulu, Hawaii. And I've been practicing law now for almost 30 years. I'm a state bar certified specialist in criminal law, certified by the state of Arizona. And my experience includes cases as serious as first-degree murder with the death penalty alleged, which we have done through trial on many occasions, all the way down to crazy little misdemeanors in city courts. And we also represent clients in both state court and in federal court. We have a lot of federal experience, and we do cases nationally. That means that even though we're not licensed in every state in the country, there's a rule called the Pro Hac Vice rule, which allows us to represent people in other states. In essence, we get admitted and permission from the court to practice in another state for one case, which we've done on many occasions. Our law firm is also a very pro-freedom law firm. You may have gleaned that from the name, the Attorneys for Freedom. What that means is we are all activist, pro-freedom attorneys. We care about changing the world. And our law firm is actually the firm that founded the Live and Let Live global peace movement. So if you're interested in that, you can check that out at liveandletlive.org. We also do appellate work as well. I've personally argued in front of the Ninth Circuit Court of Appeals on several occasions. I've also been successful there. So if you have a problem with a criminal law type of a case, this is definitely something that we can help you with. We also do civil rights cases, personal injury cases, and civil litigation cases. And if you're located in either Arizona or Hawaii, you're eligible to enroll in our Attorneys on Retainer self-protection program, which is very relevant to what we're going to be talking about here today, which is rights and responsibilities for gun owners. And finally, if you're out of state and you're interested in our Attorneys on Retainer program, this is a way you can get our law firm on the hook. You actually become a client of our law firm, and we can represent you wherever you are, especially on criminal cases, for a dramatically reduced fee. So if you're interested in that, check out the Attorneys on Retainer program. Just go to attorneysforfreedom.com and click on the Attorneys on Retainer tab. So today, what I want to tell you about is the 5 most important things that you need to know if you're going to carry a firearm, even if you're going to possess a firearm in your home. These aren't the 5 things that you're going to get from any book. No concealed weapons instructor is going to tell you about these 5 things. These are the 5 things that I have distilled down from doing many, many gun cases over my almost 30 years of representing people. I've also been a speaker at the Crossroads of the West gun show here in Arizona for about 2 decades now. So I have presented on the legal rights and responsibilities of gun owners for about 2 decades. So I know exactly what questions you're thinking about as a gun owner. And what I've done is really stories from the trenches in tips from representing people for almost 30 years on gun cases, the things that you need to know. So let me just give them to you numbered 1 through 5. Number 1, just shut up. Now, I wish I could just say that and we could just move on. You would just accept that. But I already know from representing people over 3 decades that people don't listen to that advice. They want to talk to the police. So I started thinking to myself, why on earth do people still talk to the police after the attorneys tell them, look, just shut up. Don't make any statements. Well, first off, they may forget that advice. I think it's very stressful when a police officer has been called to the scene and you're involved in a scene. So I want to give you a little bit of maybe way to remember my advice. The police officer will remind you of this advice. They're not going to say, hey, Attorney Marc Victor told you to just shut up. I wish they would say that, but they don't say that. What they will say, number 1, you've been arrested. And number 2, you are being interrogated about what happened. The officer is going to give you the Miranda warnings. Now, there's 4 parts to the Miranda warnings. First off, the officer is going to tell you, you have a right to remain silent. I want you to pause and just think about that for a moment. You have a right to remain silent, not a preference, not a privilege, but a right to remain silent. This is a very hard-fought right that the framers of our Constitution put in there, and things that have been interpreted in years later by our Supreme Court. This is a right you have to remain silent. You should use it. Just in case this doesn't sort of refresh your memory about my number one most important thing you need to know, the just shut up rule, the officer will tell you anything you say will be used against you. I want you to pause and think about that statement for just a moment. Anything you say, anything you say. Us criminal defense attorneys who have been working these cases for many years wish we could modify that to anything you say and some things you didn't even say. Yeah, because sometimes things are written down incorrectly, right? Anything you say will be used. And how will it be used? Against you. I want you to think about that the next time if you're ever in this situation. Hopefully, if you hear that from a police officer, you will remember, Attorney Marc Victor told me, just shut up. The officer will also tell you the number 3 part of the Miranda warnings, the Miranda rule. You have a right to an attorney. They won't tell you, just not right now here at the scene. That's later on down the line. And finally, if you can't afford an attorney, which means you're indigent, then one will be provided for you free of charge. Those are the Miranda warnings. And if you're hearing that, you should be especially mindful of the just shut up rule. Now, people will still talk at this point, and I know why. I think after so many years practicing criminal defense, why people still talk. I think they apply the rules of sort of life to the rules of the courtroom. And they think, well, if I don't make a statement, then maybe this will be used against me, the fact that I've remained silent. I'm here to tell you, with very, very few exceptions, which very likely are not going to be relevant in your case, your silence cannot be used against you. What that means is, if your case goes to trial, you might be worried that the prosecutor might ask the police officer who asked you to make a statement at the scene, what happened next? Did the defendant have an opportunity to make a statement? And then you're worried that the officer is going to say, yeah, I asked him what happened, and he just said, I'm going to remain silent, or I want my lawyer, or something like that. And then the jury will hear this, and the prosecutor will then argue, well, if he really wasn't guilty of the crime, why didn't he just say so at the scene? Why did he choose to remain silent, or even worse, ask for a lawyer? I want you to know the rules of the game, the way trials work, they don't allow this. And so what's actually going to happen is when the prosecutor has the police officer on the stand, they're going to skip right over this part. The officer's not even going to mention that the officer asked you what happened, and then you said, look, I'm going to remain silent, or I'm just going to shut up, or I want my lawyer. I like, by the way, mentioning the word attorney or lawyer in there when you say, look, I have nothing to say, I want my lawyer here. If you're not sure exactly what to say, you can get one of my business cards. On the back, I've drafted a statement which is my recommendation on exactly what you should say, which also includes things like you do not consent to any searches. I'm a big fan of that. This is not going to be used against you. And if, by some chance, the officer blurts out at your trial, yeah, I asked him if he had anything to say, and he said, I want my lawyer, he had nothing to say, or chose to remain silent, or something like that, this very likely could result in a mistrial. If your defense attorney is not sleeping at the switch, your defense attorney will generally stand up and say, excuse me, Judge, can we approach? Ever wonder what happens at those sidebar hearings when the prosecutor and the defense attorney sort of huddle up with the judge, and then they quietly say things up there at the bench? What's said in this circumstance is something like, hey, Judge, did you hear the police officer just commented on my client's right to remain silent? And if this was done intentionally, maybe the prosecutor asked a question that sort of provoked this type of a response, the proper remedy for this is going to be a mistrial. If it's intentionally done, there may not even be a new trial. That could be a dismissal with prejudice. If it's accidentally done, like, for example, the prosecutor says, I don't know why the police officer said that. The police officer's brand new. Maybe the police officer doesn't know this rule or something like that. Then this would maybe be deemed as sort of an accidental or an inadvertent type of a statement. You're still going to get a mistrial, very likely, and the case likely will be brought again with a new jury. It's also possible, if it's just sort of a tangential mention, maybe the officer just very off the cuff says, oh, he didn't have anything to say, and we move on or something like that. I would still ask for a mistrial under those circumstances if I was the defense attorney, and you might get one. But sometimes a judge will want to just instruct the jury to disregard that statement, strike it from the record. But we defense attorneys refer to that as unringing the bell. Usually once they've heard it, they can't forget that they've heard it. But in any event, the point that I'm trying to make here is don't worry about exercising your right to remain silent. In addition to that, this isn't a reason for the officer to arrest you. The officer doesn't get to say, look, you didn't make a statement, and therefore I'm going to arrest you and take you away. Now, it's true, all the officer needs is probable cause to arrest a person and take them to jail. However, one of the things amounting to whether probable cause exists or not is not that the defendant failed to make a statement. You got a right to not make a statement, and you shouldn't make a statement, especially at the scene. Other reasons why you shouldn't make a statement. Once you make a statement, that's your legal theory. So, for example, if you say, like some people recommend, and I do not, that, hey, I was in fear for my life. Maybe that's why I discharged my firearm, or that's why I pulled it out, or something like that. That's your theory. You're stuck with that theory. Maybe the case had a different theory that might have been better. Like, for example, you were acting to protect the life or against a serious physical injury, a third party, someone else, and you have a right to do that. In all states, you have a right to at least stand in the shoes of a third party, and to the extent that they can defend themselves, you can defend them. But if you said, I was in fear for my life, now that theory's out the window. There can yet be other reasons why a person is justified in threatening or using deadly physical force. In Arizona, for example, and by the way, I want to say that my advice here applies to most states, but not all states. I'm sitting here as I speak in Arizona, so some of this advice is specific to Arizona. If you want to know exactly what the rule is in your state, you need to speak with a licensed attorney in your state. Most of this, of course, is federal constitutional law, so it applies everywhere. But there are a few things that I'll flag, like right now, the rule in Arizona. And so in Arizona, there's a statute called the Crime Prevention Statute that allows you to threaten or use deadly physical force, not because your life is threatened or the life of a third party is threatened, but because you are acting to prevent another person from committing a certain crime that's on the list of crimes in the statute under the Crime Prevention Statute. ARS 13411, for those of you who are interested in looking it up. In any event, you don't want to make any statements right away because it can limit legal theory. So keep your mouth shut. Let the defense attorney decide what legal theory makes most sense. Also, keep in mind that if you're making a statement at the scene, this is the worst possible time to be making a statement, right? If you've been ever in a situation like this, you know these are very stressful situations. The police have just shown up. Maybe there's been a shooting. You're probably got adrenaline flowing through your veins. You're hyped up. You're excited about it. You may not include every little detail of what happened. And you know what's going to happen if you leave some little detail out. The prosecutor is going to notice that at your trial, which may be a year or even 2 years later down the road. You're going to have to explain why you didn't include that fact at the beginning. You may have been giving just a quick overview, and then later on, after you've had a year or 2 years to go back and think about every little detail, you say, oh yeah, this was happening, or that is what was happening. And the prosecutor certainly will make much to do out of the fact that you didn't say that at the scene. The question will be, oh, do you remember it better now than you did right there at the scene? So don't open your mouth and make a quick statement while you're under the stress of the incident and the event, because you may leave something out. You may also get something wrong. Can also be things that occur, which I've seen in many cases where I've represented people, where there'll be a statement in the police report and the defendant will tell me, my client will say, I never said any such thing. That's true. A police officer may write down something incorrectly. They may misunderstand something you said. Maybe you said something that wasn't clear. The officer may, for example, say, where did the person enter your home? You might say, over there. You might be pointing to the door. The officer might think you pointed to the window, and the officer may write down in the report, he said that the person came in through the window. And then later on, when you say at your trial, no, I told the officer he came through the door, the officer is going to say, no, I wrote it down in my police report. He said the person came through the window. Also, let's just be candid about this. Not all officers are honest, right? It's been my experience over about 30 years now that most police officers are pretty good. The vast majority, I would say, they're trying to do their best to take down the information and the evidence in an unbiased way. But that's not true of all of them. Like every other profession, right? There are good and bad everywhere. You don't know who you're dealing with when you are talking to a police officer, especially at the scene. So keep your mouth shut. There are police officers out there who are dishonest, who are liars, who don't like the fact that citizens have firearms, who may intentionally write down something incorrectly because maybe they've made up their mind and they think you're the bad guy. Keep your mouth shut. You don't want to trust your freedom, what might be 5 or 10 or 20 or more years in prison, to the honesty of a police officer or anyone else for that matter. Now, I hope I've made the case to just shut up if you're in a situation like this. But now that I've made the case, I want to give you some exceptions to the rule. There are some exceptions, and we should talk about them. First off, I often get asked the question, hey, Mark, should I call 911 after an incident like this? There's no perfect answer to this question. My preference is that you don't call 911, but that you get somebody else to call 911. This needs to be done, obviously, very quickly. I do not think you should call your attorney first and then call 911, because the fact that you called your attorney before you called 911 is something that would be admissible, at least potentially, at your trial, and juries can make inferences as a result of that. So get 911 called. Best case scenario, get a friend or maybe somebody else who was there to call 911. Now look, we're not looking to lay out all the details here. The call should essentially be, hello, there's been a shooting. Here's the address. Please send help. Goodbye. If you have to call 911, be very careful not to say anything more than that. There's been a shooting. Please send help. Here's the address. Goodbye. That's it. The 911 operator is, of course, going to try to get lots of details and information about what's happened. You need to be prepared that the police are coming, so whatever you do, make absolutely certain that you are not a threat when the police officers show up. They don't know who's the good guy and who's the bad guy and whether you got a gun or don't have a gun. So best case scenario, when a police officer shows up after a shooting, make sure it's very clear you don't have a gun in your hand and you're not a threat, and you want to make absolutely certain that there's not a misunderstanding and you don't accidentally get shot by the police officer. But do not make any kind of a detailed statement to that 911 operator. You don't have to, and you shouldn't, but I do think 911 should be called. Also, traffic stops. Look, I'm not saying never talk to the police. If you want to try to talk yourself, talk some officer, I should say, out of giving you a speeding ticket at the scene, have fun. Make sure that obviously there's nothing else going on, right? If you have some kind of contraband in your trunk or something else, then you probably follow the just shut up rule. But if you're just speeding and you want to try to charm that police officer into giving you a warning or something like that, have fun. Little tip on this point, I've found that officers are generally pleasantly surprised and very impressed when people just simply tell the truth. You may be able to get out of your speeding ticket by simply saying, yep, officer, I'm sorry. I was definitely speeding. I'm sorry about that. I won't do that in the future. Yes, you just destroyed your chances of winning your traffic trial, but you're probably not going to win that anyways. If you notice all the revenue that is dragged into the city or the state from speeding tickets, probably you're not going to win that. It's going to be your word against the police officer's word. So you may be willing to give that up and just own it. And you'll find that many officers actually will give you a break just because you're honest. Hopefully you're not going too fast over the speed limit at the time. So traffic stop's not really what we're talking about here when I'm mentioning the just shut up rule. Another exception is I'll call the after consultation with an attorney rule. Now, even though the officer might tell you, hey, look, now's your chance to make a statement. This is it. I need to know what happened. Don't buy it. You can make a statement at absolutely any time, up to and including your trial for the very first time. And it might be the case that it makes sense for you to make a statement. I've done many gun cases where we actually decided to make a statement. But make that decision after you review the police report, witness statements, any video, a body cam video, things of that nature. So you get all the facts of the situation, and it might make sense to make a statement at that point. I have successfully made statements, even talked some prosecutors out of bringing charges. So I'm not saying there's never a time to make a statement, but the best time is after you meet with an attorney and consult with the attorney, and the attorney says it's in your best interest to actually make the statement. Now, a couple other exceptions to the rule. These are specific to Arizona, but there are versions of this that apply in other states. If the officer determines that they have reasonable suspicion that you've committed a crime, then the officer can require the person who is detained to give their true full name. This doesn't necessarily mean you have to present a driver's license. If you're driving the vehicle, then you're going to have to present a driver's license. But if you're not driving a vehicle, at least in Arizona, your obligation is to give your true full name. And if you don't, you can be charged with a misdemeanor crime, and the officer could arrest you for that type of a violation. Now, if the officer's just asking your name and there's no reasonable suspicion to detain you or anything like that, then you're not required to give your name. By the way, it's always a good question to ask an officer, excuse me, officer, am I detained or am I free to leave? The officer says you're free to leave, then you might say, have a very nice day, officer, I'll be on my way. And by the way, while I'm on this point, maybe drop a little footnote here. I think you should be very respectful whenever you're talking with a police officer. That doesn't mean you have to actually respect officers, right? I mean, it's a relatively free country. You don't have to respect police officers. You can hate police officers if you want, but you ought to at least appear to be respecting the police officer at the scene. Police officers have a lot of discretion, and they can exercise it at the scene to make your life more miserable. So whatever you say to the police officer, say it with kindness, say it in a respectful type of a way. Don't ever hesitate to blame it on me. You can say, hey, I've got a friend, attorney Marc Victor. He's with the Attorneys for Freedom law firm. Marc would kill me if I made a statement. Feel free to follow up with. And I'd like to call Marc right now. And if Marc says it's okay to talk to you, then I'm happy to give you a statement. You should know that although I'm very easy to get a hold of, you can call me anytime. I'm available 24/7, 365. But there's no lawyer at my law firm who's going to advise you to make a statement at the scene when we're not there, and we don't know anything about that case. I think you'd be very hard-pressed to find any competent criminal defense attorney anywhere who's going to advise you to make a statement at the scene. Rest assured, if you're getting that advice from an attorney, probably best to move on and find a different attorney. And then finally, if you're asked, this is another one that is applicable in Arizona, but if you're asked by a police officer, do you have a concealed firearm on your person during a stop, could be even a traffic stop, you are required in Arizona to answer that question truthfully. You don't have a right to remain silent and fail to answer this question. Now, this hasn't yet been challenged in Arizona. I personally believe this is unconstitutional because it violates your Fifth Amendment right to remain silent. However, the way the law stands at the moment in Arizona is you are required to truthfully answer that question. If you don't answer or you lie about that, you can definitely be charged with violating this section and not giving a truthful answer to the police officer. Okay, so all of that is under number one, just shut up. I hope you remember that rule. And by the way, this is a good rule for virtually any time you are in contact with a police officer. If you don't know who you're dealing with, or you're skeptical about what the officer's motives are, you don't need to make any statement. And you may also mention, hey, I want my attorney, or I want my lawyer present. If you equivocate, if you say, you know, I'm not sure if I should make a statement or not, the law says this isn't good enough. You have to be very clear. I'm exercising my right to remain silent. I want a lawyer present with me before I make any statement. I also just will add in there as a footnote, do not consent to any searches either. Number two, most important thing you need to know. Look, self-defense is all about reasonableness. Think about it like this. Imagine a trial on a self-defense issue. And by the way, we have tried cases here at our law firm, gun cases. Not a lot of gun cases go to trial, but we do have trial experience in gun cases, so we know what we're talking about. We've picked juries, we've asked them questions that I'm going to get to in just a few minutes here. But imagine the way the trial is going to go is all the evidence will be presented by the state, which means all the witnesses, all the statements, any video, all of that is presented. And then whatever the defense wants to present is presented. Imagine if the judge turned to the jury at that point and said, look, ladies and gentlemen, now you've heard everything, you've seen everything, you know everything, here's what we need to know from you. Did the defendant act reasonably? That's really the question in a self-defense case. You'll notice as you review statutes and look at the rules involving self-defense, that word reasonable will come up a lot. At the end of the day, that's really what self-defense is. It's considering all the facts and circumstances of whatever it is that happened in this case. Did the defendant act reasonably? And if the answer is yes, well, then you probably owe your defense attorney a nice dinner somewhere, because that means you're acquitted. The defense attorney did a good job for you. If the answer is no, well, this is very bad news for you. This means probably you're going to be taken into custody and you're going to serve some time. It's all about reasonableness. That's what it means. So what the heck does reasonable mean? Well, we have some examples. Our legislature has told us in the form of statutes, which are then translated into jury instructions, some predetermined rules about what's reasonable. I'm going to give you a few examples here. Number one, if the threat against which you are acting to prevent, right, the thing that's going on that's causing you to use ordinary physical force or threaten or use deadly physical force, if that's not imminent, in other words, if the threat isn't right now, then I'm here to tell you it's already unreasonable. So observe the difference between somebody who says, look, I'm going to punch you in the face tomorrow. Can you punch him in the face now and claim self-defense? You can do it, but you're not going to be successful because the threat isn't imminent. It needs to be right now. It is happening right now at this moment. So that's an important concept to understand. Whatever's going on, if that threat is not imminent, you don't have a right to self-defense. So don't do it unless it's imminent. It's got to be a right now situation. Another example is the mere words doctrine. Let me explain what we're talking about here. I don't care how offensive what it is that somebody said to you. You are never justified in using self-defense, or said another way, it will never be seen as reasonable for you to use either ordinary physical force or deadly physical force if what you are responding to are words alone. That's not enough. You need something more than words. And I don't care how offensive the words are. Somebody might say something horrible about you or your spouse or your religion or your Bible or your favorite sports teams or America or the flag or anything else that you hold dear. You don't get to use self-defense in that case. Now, keep in mind, just because offensive words are used, it doesn't mean that self-defense can't apply, right? Because words could be coupled with action. The difference between somebody saying something offensive and somebody saying something offensive while they got their fists like this and they're approaching you, those are two completely different circumstances. This is what lawyers do, right? We go through the facts of what's happening because we understand that mere words alone isn't going to get you to self-defense. But words coupled with action that prevent an imminent threat, now you might be talking self-defense. So keep that in mind. I don't care how offensive it is. If you can't resist the urge to walk away, or at least not pull out a firearm or get involved in a self-defense situation just because you heard something that was offensive to you, you're probably not well suited to be carrying a firearm. And then finally, the third example of predetermined rule about reasonableness that I'd like to give you is deadly physical force is never going to be justified if the reason you're using it is to just protect property, period. I don't care how valuable the property is, at least in Arizona and every other state that I'm aware of, you never get to either threaten or use deadly physical force just to protect property. So what does that mean? Does that mean if somebody's trying to steal your TV, you can't pull out your firearm and point it at them and say, hey, stop, don't steal my TV? That's exactly what I'm saying. But there again, observe, there's a difference between I pulled my firearm and pointed it at him to stop him from stealing my TV, and I pulled my firearm and pointed it at him because while he was stealing my TV, he was threatening to hit me over the head with it or something like that. That's a different set of circumstances. Also a good reason to just follow the number one, just shut up rule, right? We'll figure that out later. But don't make any statements at the scene, and absolutely do not ever use or threaten to use deadly physical force if the only reason you're using it is to protect property. And keep in mind, the jury is going to decide what is reasonable. That's not you. It's going to be a randomly selected group of people from the local community. They will decide what's reasonable, and they're not all going to be of one mind, right? Some of them supported the other political party, the one that you don't like. Some of them have different attitudes than you have about firearms and lots of other things. When I pick a jury on a gun case, I often will ask them, raise your hand if you think the gun laws in this state are too strict. And raise your hand if you think they're not strict enough. And I'm here to tell you, even in Arizona, a very pro-gun type of a state, more people always raise their hands when the question is asked, do you think the gun laws are not strict enough? More people will raise their hands. And inevitably, I will get people who will say, I don't know why anybody who's not a police officer should have or carry a firearm. A good lawyer will do the best to keep these people off your jury, but sometimes jurors don't answer the questions accurately, or sometimes they wiggle around the questions. Sometimes people have different motivations. You need to be very careful. What I'm getting at here is you don't want to be in this position to be judged by a randomly selected group of people on what's reasonable, right? You've been on the planet long enough to know people disagree about the word reasonableness. Don't put yourself in that position. You have no idea who's going to be on your jury. And also, juries vary by community. Keep that in mind. You may live in a community where lots of people carry guns and like guns and have guns, but you may be in a situation in a completely different community where people think bad of people who carry guns or have guns. It's all about reasonableness, and reasonableness can be a squishy kind of idea. Keep that in mind when you are thinking about, should I pull out my firearm? Do you really want to be judged to be reasonable or unreasonable by a whole bunch of people you don't know anything about? Number 3, you think it's all about the law. And it's about the law. The law is important. But your case is probably going to turn on the facts. That's right. We lawyers, we don't hardly ever argue about the law. We know what the law is. Sure, a situation will come up from time to time when maybe I'll raise a statute and the prosecutor will say, no, I don't think that statute applies, or I don't know how it applies, or we'll get into some kind of an argument. But 9 times out of 10, we're going to be able to work that out. We can find a case or something that will explain how the law applies in this type of a situation. What happens in these cases very often is I get the case, and I'm representing my client, and I know my client's story, and then I call the prosecutor, or I meet with the prosecutor in person, and I say, hey, look, I don't know why you're prosecuting my guy. Here's what happened. This happened, this happened, this happened, this happened. So why are you prosecuting my guy? The prosecutor will often say back to me, those aren't the facts I'm working with, Mark. I have a completely different set of facts. Keep in mind, people will have good faith disagreements on facts. In other words, they may be looking at the same thing and just have seen it differently. They may remember it differently. Or people can have bad faith disagreements on facts. That's right. The victim will have a different version of events than you do. You might say, look, all I did was put my hand on my firearm and said, leave me alone, I got a gun. The victim might say, that's not what happened. He pulled out the firearm and he pointed it at me and said, he's going to blow my head off, or something like that. And if the victim has friends there, you should probably expect that the victim's version of events will be corroborated by the victim's friends. And keep in mind, who's going to be the most biased person in the courtroom? You know who that is. That's you. The prosecutor is going to argue, ladies and gentlemen, you can't believe the defendant. The defendant has the most to gain or lose out of this case. You're always the most biased person in the courtroom. So you got to be very cognizant of the fact that juries find facts. They don't find the law. The judge gives them the law. And there will be disagreements on the facts. And most trials turn on which version of the facts do they believe. So you got to really calculate into your analysis how many witnesses are going to be on the victim's side and how many are going to be on your side. And do we have video of the event? Hopefully we do if you acted properly, but you might not always have video of the event. It may not show what happened at the relevant time. It may not be a complete video. You got to be very, very careful. The jury decides the facts, and the case is probably going to turn on what version of facts the jury buys. Number 4, very, very important concept for you to understand. Almost all gun crimes carry with them mandatory minimum sentences. Okay, what's a mandatory minimum sentence? Ladies and gentlemen, in my opinion, this is a huge problem with our law, something we need to change. Mandatory minimum sentences are when the legislature passes a law that tells the judge, hey judge, if somebody is convicted of this particular crime, you have to send this person to prison, usually for no less than this amount of time. I will tell you, in Arizona, the most common gun crime to be charged with when you pull out your firearm and a prosecutor says you shouldn't have done that is aggravated assault. And by the way, you don't actually have to hit another person or even touch another person to actually be guilty of assault. Assault can be just simply putting another person in fear of an imminent physical injury. Think pointing a firearm at somebody. If you point a gun at somebody and a prosecutor decides that's not a justified act on your part, it wasn't self-defense, they're going to charge you with aggravated assault. In Arizona and in most states, this is going to be seen as a dangerous offense. What that means is you're looking at a mandatory minimum sentence. The mandatory minimum for aggravated assault in Arizona for somebody who has no priors whatsoever, 5 years. 5 to 15 years with a presumptive term of 7.5. So in other words, what I'm getting at here is if you take that case to trial and you lose that case and the judge has lots of sympathy and compassion and finds lots of mitigating factors in your case, the best the judge can do is to give you 5 years in prison. This is a huge problem for you. Most gun crimes are mandatory minimum crimes. There are 1 or 2 that don't have a mandatory minimum, but the net effect of this mandatory minimum means that you're probably going to take a plea. What am I saying? Why would I say this? Because in the very high 90 percentile, 97, 98% nationally, cases that are charged end in pleas. And a lot of this can be attributed to mandatory minimum sentences. Let me break this down a little for you. The best any competent criminal defense lawyer is going to give you at trial is about 50%. We're not going to venture out. We've all seen All of us criminal defense lawyers who have been doing this a long time have seen juries do crazy things. We've all won cases that we thought we were going to lose. We all lost cases we thought we were going to win. Juries are unpredictable. And so you are not going to roll the dice on a mandatory minimum prison case, especially if the prosecutor offers you a probation-eligible plea. Now look, mandatory minimum sentences, these aren't lost on prosecutors. They know exactly why they're there and how they work. They know you're probably not going to roll the dice at trial, especially with a 50% chance of going to prison. You're very likely to take the plea that they offer. That's why most people take the plea. You're not going to be very happy about that, because if it's a felony plea, you're probably going to end up being a prohibited possessor. You may plead guilty to something that actually should have gone to trial in a close case or something. Imagine if I said to you when I pulled you off to the side, hey, look, 50% is the best I can give you at trial. But look, you got a really good case at trial. I like it a lot. And in reality, probably 90% chance we win. Okay, I'm not going to ever say that to you. But imagine if your criminal defense attorney said that to you. That's still a 10% chance that you're going to go to prison. Are you really going to take a 10% chance that you're going to go to prison? Especially in the case of an aggravated assault, where I just explained, you're looking at 5 to 15 years in prison. And if you got a deal in your hand that's a probation deal that's going to give you maybe 100% guarantee that you're going to get probation, I can assure you, it's a very rare client of mine who's going to say, I'm going to roll the dice, even at a 90% chance of winning, which is a 10% chance of going to prison. So you got to be very, very careful and mindful about how these mandatory minimums work. Keep in mind that we don't get to tell the jury at all about what the punishment is. Some of the members of the jury might be thinking in their head, this guy's got no priors. Even if we find him guilty, he's probably going to get probation, no big deal. Just as an aside, I think this is a mistake in the law. I think we should be able to tell the people on the jury, hey, this is a really serious case. If you come back and find the defendant guilty, there's a mandatory minimum sentence. The defendant will have to go to prison for between 5 and 15 years. Now, nowhere do we get to tell the juries this. The theory is that the jury is just deciding whether you're guilty or not. They're not to consider punishment. But in reality, as some commentators have pointed out, we take decisions more seriously when we know the decision is a very, very serious situation where someone's going to go to prison. Maybe they comb over the evidence just a little bit more carefully and look at it more carefully, rather than they think, well, he's going to get probation anyways, and maybe he should learn a lesson and move on. So this is, I think, a problem in our criminal justice system, that many people on the jury won't know that you're looking at a mandatory minimum punishment, and you actually are looking at a very, very serious situation. So keep that in mind. You're probably not going to trial in any event on your gun case. I think it's a sad state of affairs. Incidentally, I support a change in the law that would say something along the lines of, notwithstanding any law to the contrary, the sentencing judge always has the discretion to put a defendant who's been convicted of any crime on probation. If that happened, I think you'd see a lot better pleas in the system, and I think you might see more cases go to trial. And there are many cases, especially in the self-defense world, that are in a gray area. At the gun shows, I get a lot of questions. Hey, Mark, if this happens, and this happens, can I shoot the person? The way I hear this question is, hey, Mark, I'd like for you to predict for me how a randomly selected group of people from the local community will view the facts of this case. Will they think I acted reasonably or unreasonably? And the answer is, we don't know. We don't know who those people even are. So it's very difficult to make this determination. So keep that in mind when you're thinking about pulling out your firearm. You're probably going to be faced with a mandatory minimum sentence, and this is going to make life for you much more difficult and much more likely that, unfortunately, you're going to want to accept the plea. Now, I have had clients who have rejected the plea and said, I'm going to trial, and I have had situations where that's turned out favorably for my client. But I'm telling you, it's a big roll of the dice, and probably you're not going to do that. And when you don't do that, you're going to wind up accepting a plea that you're not going to be happy about. So The best case scenario here, avoid the situation. Yeah, that's what I'm saying. I recognize that in Arizona and many other states, you have a right to stand your ground, as you say. In Arizona, we say you don't have a legal duty to retreat. In other states, like for example, Hawaii, where we practice, you do have a legal duty to retreat if you can in complete safety. That's the law. That's not necessarily the smart thing to do. I'm suggesting you do the smart thing. And if you can retreat safely and avoid the situation, that's always going to be your best option, right? Use your brain and avoid going into situations that put you in a situation where you're making a tough decision about pulling your firearm. Okay, number 5. Let's say you've done everything you can do, and now here you are. You're in a situation where you're thinking about pulling out your firearm. What on earth should be in your head at the time? Okay, I deal with this question a lot. Let me tell you what I've been telling people over roughly the last 30 years. Of course, I think you should avoid this situation. But if you're in this situation, best case scenario, you give me a call, right? Call me up. And then I'll answer the phone and you'll say, hey, Mark, I'm thinking about pulling out my firearm. And I'm going to ask you a bunch of questions. Who are you? What is your relative size to the person who's creating the threat? And by the way, do they have any weapons? What's the distance between you? What are your other options? Can you safely retreat? It'll take me about an hour to analyze the situation. And even then, I'm probably going to give you a very qualified type of an answer. Okay, what's the problem here? You know the problem here, because we've already discussed imminency. If you got more than just a few seconds to think about this situation, I can already tell you it's not imminent. Don't pull out your firearm. So we got to come up with something that you can do in just a few seconds to figure out, is this the right time to pull out my firearm or to threaten somebody and even tell them I've got a firearm and start discussing a firearm, maybe put your hand on the firearm or something along those lines. Okay, in order to answer this question, I want you to think that if you do pull out your firearm, you're going to be prosecuted. Now, before I get into that, let me just say, this isn't the case in all circumstances. I have had people who have pulled out their firearm, who have even fired their firearm, who have even killed another person, and they never got charged. We've successfully, in cases, represented people in what we call a pre-charge status and talked the prosecutor out of bringing charges. So I am not saying that every time you reference your firearm, you put your hand on your firearm, you take your firearm out to display your firearm, I am not saying that every time you're going to be prosecuted. But I want you to think that you are. You need to be prepared to be prosecuted. What does that mean? Let me break it down for you. You should imagine that after you take out your firearm or threaten somebody with your firearm, the police are coming. And they are not going to be very happy with you. They're going to escort you to the ground. That's what your police report's going to say. That's one way of saying it. Another way of saying it is they may slam your face into the concrete. That could happen too. You are likely going to be arrested. They're going to put on the handcuffs, which may be too tight. They're going to cuff you and then stuff you in the back of the police car. They're not going to believe a word that you say. They're then going to take you to jail. They're going to ask you questions about what happened. You're going to remember my number one most important rule, and just shut up, hopefully. Then, at least if you're in Arizona, and in many states, you're going to be put in front of a judge pretty quickly. 24 hours in Arizona. In some other places, 48 hours. And that judge is going to conduct a hearing about your release conditions, the conditions under which you can be released from the jail. I know you think you're going to have a big, long, fair kind of a hearing here, but what I want in your head is that that judge is already going to read a short statement from the same officer who decided to arrest you. In Arizona, this is called the Form 4. And it's going to summarize from the officer's perspective why you're the bad guy. And the judge is already going to have in the judge's head what the bond should be. And you should imagine it's going to be a really high bond. It may also be a cash-only bond. That's right. Cash-only bonds are popular today. They make it more difficult to get yourself out of custody. You can't just have a bondsman post a bond. They actually got to put up the cash, so the court is holding it. It makes it very hard. Then you have to think that you probably are going to be charged with a very serious crime. Think aggravated assault, think mandatory minimum, think 5 to 15. And you are going to have to hire a criminal defense attorney to represent you. And I know how much you want to spend on a criminal defense attorney. Zero, right? That's how much you have budgeted to spend on a criminal defense attorney. Which is why, by the way, I very strongly recommend, if you are in Arizona or Hawaii, or even in any of the other states, that you look into the Attorneys on Retainer program. This will solve that problem for you. Just check it out at attorneysforfreedom.com. Check out Attorneys on Retainer. This is a way to resolve that very high cost of getting competent representation in the event you are charged with a crime. But it's say if you're not in the Attorneys on Retainer program, you're going to wind up spending an awful lot of money on a criminal defense attorney just to defend you. You should prepare for at least a year of misery. What do I mean by that? It's the last thing on your mind when you close your eyes at night and the first thing you think of when you open your eyes in the morning. You're going to have a miserable, stressful, aggravating period of time defending yourself against a very serious mandatory minimum charge. It's going to take over your life. And at the end, as I've explained, when I talked about mandatory minimums, you may wind up taking a plea, and you're probably not going to be happy about that. You may have a felony on your record. You could be a convicted felon for the rest of your life. You may be a prohibited possessor, and you may either be stripped of your gun rights for the rest of your life, or if you plead to a certain type of charge, you might be eligible, at least in Arizona, to regain your gun rights. All that's miserable. Let's put that whole mess under the category of being prosecuted. Okay, back to our analysis. What should I do if I've only got a couple of seconds in my head to think about, should I pull out my firearm or not? That ugly picture I just painted about being prosecuted, I want you to think about that's what's actually going to happen. Now, what I want you to think in that couple of seconds is what's about to happen if I don't pull out my firearm? Is that worse than being prosecuted? If it is worse than being prosecuted, then I would say pull out your firearm. Okay, how do we apply this? We'll call it the Marc Victor rule. How do we apply the Marc Victor rule on what to think about? Well, let's imagine, we'll run a few scenarios here. Let's imagine if you don't pull out your firearm right now, you're going to be dead. Okay, prosecuted, that's pretty bad. Dead, as far as we know, that's pretty bad too. I think I'd rather be prosecuted than be dead. Therefore, pull out your firearm. Okay, that should be an easy one. We'll try to make this one a little bit more difficult. Let's say if you don't pull out your firearm right now, then somebody you love, or maybe you like a lot, is going to be dead. Okay, same analysis. Would I rather have someone I love or like a lot be dead, or would I rather be prosecuted? I'll go with prosecuted. Therefore, pull out your firearm. Okay, final example. This is one actually drawn from my experience in representing people. Had a client one time, came into my office, sat down, charged with aggravated assault, mandatory minimum, 5 to 15 years. I asked him, why did you pull out your firearm? And what he said to me was, I was about to be disrespected. Okay, well, let's run that one through the Marc Victor analysis. Would I rather be prosecuted or disrespected? Look, nobody likes to be disrespected. I don't like to be disrespected. You probably don't like to be disrespected. But your choice is between being disrespected or being prosecuted. What's the answer here? Disrespect me all day long. Be disrespected before being prosecuted, right? So I hope I've sort of conveyed to you how serious I want this situation to be before you pull out your firearm. Look, if you're the kind of person who's carrying a firearm, who's just kind of itching for that opportunity someday to pull it out and be a hero, my guess is you're probably going to be better off not carrying a firearm at all, right? I don't think that should be the disposition of somebody carrying a firearm. Hopefully your attitude is, carrying a firearm's really boring. I don't ever want to have to pull it out. I don't ever want to have to tell anybody I'm carrying. I don't ever want to have to put my hand on a concealed firearm or anything like that. It should be boring. And chances are you're never going to have to pull it out. I admit, if it is going to cost you your life or somebody you love or like a lot, fine, that's the time to pull it out. But don't go pulling your firearm out for less than that. I think it really, really should be that serious before you pull out a firearm and subject yourself to being prosecuted. Okay, so last point here before I end this video. If you do pull out your firearm, remember there's a difference between pulling out your firearm and pointing it at another person and then pulling out your firearm and just simply displaying your firearm, maybe holding it up in the air. Generally speaking, there should be an escalation of the amount of force that you're going to use. Remember, the law requires that even if you are justified in acting in self-defense, you can only use the least amount of force that is reasonably necessary to repel the attack. So what does that mean? If you can just say, hey, leave me alone, I got a firearm, do that. If you got to put your hand on it and say, leave me alone, I got a gun right here, do that. If you got to pull it out, then don't point it at anybody. You can point it up, you can point it down. I like the idea of backing away as you're saying this. Hey, leave me alone. I don't want any trouble, not looking for any problems. Last resort, pointing at somebody. Always remember, be very careful. Keep your finger off the trigger unless and until you intend to discharge a round at somebody. Use the least, threaten the least amount of physical force or deadly physical force necessary to repel the attack. You don't get carte blanche just because you get to act in self-defense. You don't get to use more force than is reasonably necessary. This also applies to ordinary physical force, right? If you can push somebody away and that ends it, that's all you get to do. It doesn't mean you got carte blanche to start punching somebody in the face until they're a bloody mess. You can use more force than is reasonably necessary, even if you were justified. And if you do use more force, you'll be considered the aggressor, and you could be charged even if you were justified in acting in self-defense. Okay, that's my final point on this. So in conclusion, again, my name is Marc Victor. I'm very easy to get a hold of. If you have questions or comments, you can hit me up directly. It's Marc, M-A-R-C, at attorneysforfreedom.com. Check us out on the internet. Just go to attorneysforfreedom.com. There are lots more videos and other pieces of advice here. I'd love to hear from you. Whether you have a compliment or a critique, as long as you bring it civil, you will get a response from me. Keep in mind and check out the Attorneys on Retainer program. Important thing to know about this program, you gotta be signed up before you have a problem, right? In order to get the discount. You don't get to first get charged with a crime and then sign up for the Attorneys on Retainer program and expect to get us at a discount. If you're in Arizona or Hawaii, you can get us on the hook for $25 a month. And if you do get charged with a crime where you're saying, hey, I acted in self-defense, all of the legal fees are entirely covered. That's right, you don't have to pay a dime to have us standing by. You're actually a client of the firm. There's not some insurance company that's going to say, look, if you're found guilty or you plead, like 90-something% of people will, you're subject to repaying the benefits. That's not the case when you join the Attorneys on Retainer program. That's because we are a law firm. And if you want to know more about our law firm, you can check us out, like I said, at attorneysforfreedom.com, and check out liveandletlive.org. This is the global peace movement that the attorneys, the pro-freedom attorneys at the Attorneys for Freedom have founded with lots of other people around the world. I urge you to be part of the solution to the world's problems, not part of the problem. Take a look at liveandletlive.org, and if you like that, hopefully you'll sign up to be a member. Again, my name's Marc Victor. Reach out with any questions or comments. Thanks so much for listening.